Hello, and welcome to today's webinar. Today we're going to be talking about 7 divorce tax mistakes to avoid. There's so many changes that come with divorce, and one that you might not think about right away is that divorce can significantly change your taxes. Whenever there's change, there's a chance to make mistakes. So today we will look at the 7 most common tax mistakes people make during and after their divorce, and what you can do to avoid these pitfalls. So today, I'm very happy to be joined by a great certified financial planner and certified divorce financial advisor, Michael Ringel. And we're going to be having a conversation, and he's an advisor with Strategies for Wealth in Wall, New Jersey. So welcome, Michael.
Good morning. Thanks for having me.
Absolutely. It's great to hear from you and work with you again. And I look forward to sharing all this information with everybody because it really is going to be helpful for people to understand this.
Absolutely. Thank you.
Sure. So just a reminder with regard to the webinar, today's presentation is for informational purposes only. It does not constitute legal or financial advice. So if you have particular facts and circumstances that you want to discuss, you should certainly consult with your attorney or financial advisor regarding that. So what we're going to cover today in this webinar are various topics, including key tax changes in divorce, hidden tax deductions you can take after your divorce, how taxes fit into your big financial picture after divorce, common mistakes that can derail your taxes and how to avoid them. Plus, throughout, we're going to be getting some great tax tips from Michael Ringel for sure. So let's get started with the seven divorce tax mistakes. Mistake number 1. Choosing the wrong filing status. Your marital status as of December 31st of the tax filing year will determine your filing status for that year. So if your divorce is finalized by that date, you will file solo, even if you were married for a good chunk of that year. If your divorce is not yet finalized, you have the option of filing married, filing jointly, or married filing separately. So we'll talk about that. So let's zero in first on people who are still married. So in choosing between filing jointly or filing separately, Michael, can you give us some pros and cons in helping people choose the right filing status and how to avoid the wrong one?
Sure. I think it's really important to, first off, take a step back with all of the, financial decisions that people have to make in finalizing their divorce. I think you're absolutely right, is take a look at their tax implication on the financial decisions that people make. And one of the decisions that people have to make is, at the end of the year, does it make sense to file jointly or to file separately, especially if you're married? And there are pros and cons to each one of them. The pro is that if you file married jointly, the taxes are lower than if you filed separately. So filing jointly, you'd be in a lower tax bracket. There's a larger standard deduction, which in essence could reduce the amount of taxes that you pay. Plus, you're also entitled to other tax credits like the earned income credit, the child care and dependent tax credit, the American Opportunities and Learning Lifetime credit. So there are credits that are available to couples that file jointly that are not available to couples that file separately. Now, if you choose to file married separately, one of the reasons you might want to do that is maybe you don't have a good feeling about how your taxes have been filed over the last few years, and you really don't trust your potential or your future ex-spouse. So sometimes if you file married separately, this way you are basically entitled to your own individual tax refund, your own tax filing, and can take responsibility for that and not for any wrongdoings, mistakes, or misgivings of your ex-spouse.
Right, and putting those trust issues aside, oftentimes it is more beneficial for our clients, or divorce clients, to file jointly with their spouse. Certainly if it's towards the end of the year, from a legal standpoint, judges are very cooperative in that they will put the divorce off until early January to allow those couples to file jointly. And I find that putting in place an agreement for how a refund or a liability is going to be handled if they're filing jointly, obviously a marital settlement agreement would address those issues so that there's no confusion, really makes the process more transparent. But, you know, from the court system, the courts are aware that it is beneficial to couples if they do, in fact, put that off. But not trusting a spouse, obviously, is significant. And if we don't have information about the other spouse's income, then we would recommend a separate filing.
Absolutely.
Okay, so now let's talk about special tax status called head of household, because we know this is really important. So when they go to file their taxes, people might be confused about what that status means. Am I filing separately, single, head of household? So can you tell us the benefits of the head of household status and who qualifies?
Sure. Most people believe, or they were taught, that once you get divorced, that you're going to be filing your taxes as a single entity. And there is another way to do that, which you mentioned, is called head of household. So you would qualify for head of household if you're single, either divorced or widowed. You don't live with your spouse, or you haven't lived with them for the last 6 months. And more importantly, you're filing separate returns. You also are going to be responsible for paying more than half of the household expenses, and also have one qualified dependent. And typically that's a child who you're paying for those expenses. The standard deduction for filing under head of household is about $6,000 more than if you filed for just a single person. So you want to be able to claim head of household if you meet the requirements, also get a higher standard deduction, which would then result in lower taxes, because the tax brackets for head of household families is typically a lot larger than if you filed for a single person.
Right. Okay. So that really would be helpful. And if there's any question whether or not, you know, a particular person qualifies, then obviously speak with your attorney, speak with your financial planner. Don't guess, because you want to make sure that you're filing under the right status.
Absolutely.
So let's move on to mistake number 2, and this is failing to use your divorce as a tax planning tool. So decisions making your divorce can have a direct impact on how much you'll owe come tax time, including these 3 key areas: your mortgage deductions, your capital gains taxes, and retirement penalties. So let's talk about the mortgage deduction. Be aware that when one party is buying out the other equity, if the other party's equity in the marital home, normally the person retaining the asset will be entitled to the mortgage and property tax deductions. If you're the spouse being bought out and maybe you have plans to rent the home for a while and not jump into another mortgage, run your taxes without these deductions to get a sense of how it really will impact you. So Michael, in this regard, if you're losing a tax deduction or if you're claiming that, what tips do you have on this issue?
Well, I think you hit the nail on the head. I think that you have to do the proper planning to find out what the financial impact is going to be should you be the one who's going to be giving up these deductions. Now, some of the deductions, especially here in New Jersey, which includes the property tax and estate tax, are limited to a maximum of $10,000 a year. And when we used to be able to have, it was unlimited. Same thing with the mortgage doesn't have the cap on the deduction, but it could have a significant financial impact. And if you do give up your half of the home, you really have to do the financial projections to see what the tax benefits or the implication is going to be, especially in your net cash flow moving forward.
Right. Absolutely. Okay. So next we talk about the other key area, which is the capital gains taxes. So let's say instead of one spouse buying out the other equity, the decision is made that they're going to sell the family home outright and then split the proceeds, which is common. So they're going to split the proceeds between the two of you. This decision can make a lot of sense for your situation, but be prepared that it could also come with tax consequences. So Michael, I'm going to look to you to explain how capital gains taxes applies to this situation and who needs to pay those.
Sure. Well, a capital gains tax is typically lower than ordinary income tax. So, for example, the capital gains tax could be anywhere between 0, 15, or 20%. And the capital gains tax is based upon capital assets. So, like you mentioned before, your home. If you file married joint, then there's a $500,000 exemption towards the capital gains. So, if the gains are less than 500,000, there won't be any taxes owed. If it's more than that, then you're going to have to pay the taxes. And if you're filing jointly, as you mentioned before, it should be negotiated in the agreement who's going to be able to afford or even pay those taxes.
Right.
It also depends, as you mentioned, when you sell the home, what your marital status is. If you're filing filing separately, then each one of you would get a $250,000 exemption towards any capital gains. But if you're the person who then transfers the home to your spouse and they sell it in the future, then you won't be entitled to anything. And it just needs to be, thought. It needs to be negotiated in the divorce process on not only who's going to benefit from the gains, but maybe there could be some sort of offset between, spouses if there are any capital gains taxes that may need to be paid in the future.
Right, absolutely. Yeah, and it is important in the marital settlement agreement to really specify this information so that the question doesn't come up later and now people are, really disputing this post-judgment. So absolutely.
Mm-hmm.
Okay, so finally we're going to talk about the third key element, which is tax penalties for early retirement withdrawals. Something you should absolutely consider as you make decisions about your retirement accounts in your divorce. So, Michael, if you can talk about the tax penalties that come up with liquidating a retirement asset, that would really be helpful, and what people can do to avoid those penalties.
Yeah, this is a key area that really needs a lot of forethought and planning. So when one spouse transfers a qualified retirement plan, qualified meaning a 401k, pension, and IRA, if it's not taken out and liquidated, then there are no penalties. Then there are no taxes either. So typically what happens is they're transferred via a qualified domestic relations order or a quadro, not for an IRA. We'll talk about that in a little bit, but transferring a 401k to a 401k. Now, if it's transferred from the ex-spouse's 401k, then the receiving spouse would open up an IRA. And if the money goes directly from the 401k to the IRA, there is no tax implication until the party takes out the money. Then it'd be taxed at ordinary income. If they choose to take it out after the divorce and after the money is moved, and they're under 59 and a half years old, then there's a potential for a 10% penalty. So in the planning that we do with clients and in conjunctions with their attorneys, if they need to take money out of the transfer from a 401k, the Internal Revenue Code has made provisions such that any money that gets transferred from the 401k to the individual person before it goes to the IRA, they won't have to pay the 10% penalty, but they will have to pay ordinary income taxes on it. There are also certain ways that money could be taken out. Under the Internal Revenue Code 72T is if you're under 59 and a half, you can actually take money out of an IRA without a 10% penalty. But I don't want to go into the weeds about how to do that. Just know that if you have an IRA and the money's there, it is possible to take money out without paying that 10% penalty.
But you would pay the taxes on it, correct?
Absolutely. You'd be paying ordinary income tax, as opposed to the capital gains tax, which we talked about a few minutes ago. That's a little bit lower.
Right. Yeah, so the quadro in the divorce process really provides assurance to the divorced couple of exactly how that asset's going to be shared. I get a lot of questions from people that are afraid that if they're sharing in retirement assets, they're going to be taxed and penalized. So your explanation really is helpful in having people understand that. And the other thing from a legal standpoint that we want to do is see see the plan documents, and then obviously the quadro gets sent to the plan administrator for approval, and then the asset is then distributed.
And I think also people need to be realistic on the amount of time it takes to actually have the money transferred from the 401k financial institution to the ex-spouse's IRA. It could take a short period of time, but they have to have expectations that it could take months, and therefore they shouldn't rely on their individual cash flow needs to live off any of that money.
Right, because one of the issues that we see come up oftentimes is the marital settlement agreement may say something like, these assets are going to be divided within 30 days. Well,
Correct.
They can say that, but that doesn't mean that the plan administrator is going to approve the quadro and that the court's going to file the order. So typically what we do is we lay out a plan by which both parties will cooperate and pay for the process to move forward. So that will happen within a time frame, and that both parties will cooperate, making any kind of preparation and cooperating with the quadro company, what have you, so that it moves forward. But really identifying a time for which it's going to actually pay out is very difficult. So I agree with you. Okay, so moving on to mistake number 3, which is thinking child exemptions no longer matter. So under the Tax Cuts and Jobs Act of 2017, personal and child dependent tax exemptions were set at $0 for tax filing years 2018 to 2025. This can be really confusing if you're new to filing your taxes on your own, or you haven't been paying much attention to all the new tax changes from that act. So if it's 0, does it still matter on your taxes?
Absolutely. It's one of those things that confused a lot of people this year is, should we even go through the process of claiming your children? And the answer is absolutely yes, because there are other tax credits available so that when you file your tax returns that you could apply for. For example, the Child Care and Dependent Care Act, dependents. There's up to $2,500 per child that's available. That's a tax credit. Difference between a tax credit and a deduction is a deduction reduces taxable income and then taxes are paid. A credit is a dollar for dollar savings in the taxes that you're going to have to pay. That's why, claiming your child as a dependent, if possible, is really important for you to save on taxes.
Okay, and what have you seen with parties alternating the child's tax credit? How have you seen that working?
I've seen it work where, couples who have an odd number of children, correct, like you mentioned, they alternate from year to year. Who's going to take the deduction? A specific form needs to be filed by the custodial parent in order to allow the deduction for the ex-spouse to take on their tax returns. And it's one way of equalizing the tax credit. Otherwise, what happens is the financial advisor and the lawyer can negotiate who's going to get all of the tax credits throughout the minority of the childhood.
Right, and you mentioned that form that has to be filled out in order to allow for this alternating arrangement. So one key element that we try to do in our agreements as well is include that those parties are going to cooperate. They're going to execute the documents by a date certain. So it's very clear as to who's responsible for what going forward. So now moving on to mistake number 4, not realizing that alimony tax rules have changed. This is a big one. This is a major change that came out of the Tax Cuts and Jobs Act that caught a lot of people by surprise. Essentially, the new tax rules apply to alimony orders put in place on or after January 1, 2019. So anything before that is still grandfathered in, but the change really comes after January 1, 2019. So previously, the spouse required to pay alimony could deduct payments from their income taxes. The spouse who received alimony included it as income. Now, this is still true for anyone who had alimony orders, like I said, before 2019, but after the rule does kick into effect. So under the new tax rules, alimony payors can no longer claim it as a deduction, and alimony payments are not added as income. So spouses who receive the alimony don't have to claim that as income. It really is a big change.
Huge.
Yeah. And how have you seen that change affecting parties, Michael?
Well, I agree with you. It was a huge change in the tax law that not many people saw coming. And basically, if you think about it, it was a tax increase for divorcing families because beforehand, the spouse making the higher income earning spouse would taking a tax deduction for the amount of alimony that they were paying, and typically they would be in a higher tax bracket than their lower income producing spouse. And if money got transferred from a higher tax bracket to a lower tax bracket, there was tax savings. Well, now, as you mentioned, you can deduct the taxes, and taxes are not, I'm sorry, and then alimony is not included in income. So basically, it's a tax increase for families and a way for the government also to receive more tax income. So it hurt a lot of families.
Yeah, and I think that equally both parties really took the hit on this change. Wouldn't you agree?
Oh, absolutely. I mean,
Right.
most people at the time of going through the divorce, were counting on this tax deduction, especially in the higher tax bracket. So, it's all around cash flow or net cash flow, and this just, decreases that, and the amount of money that both spouses have at the end of the day has decreased significantly.
Exactly. And as a divorce financial planner, what are you telling your clients about planning or how they can perhaps negotiate different alimony terms? I mean, what is your advice and suggestion?
Well, I wish we could turn back the clocks to 2017, but unfortunately we can't. So we have to come up with creative ways in order to try to mitigate that increase in taxes. So two of the ways that we help clients is we try to figure out what the taxes would have been should they, have been able to take the deduction and filed and actually claim the income and take an average of what those, what the two taxes are and negotiate a net settlement that way. Another creative way, which we've seen, is if there's enough retirement funds available, right? When let's say the higher income earning spouse put money into their qualified plan or their 401k, they got a tax deduction for it. And typically they'd be in a higher tax bracket. So one of the things that we can do is transfer a lump sum from the higher income earning spouse to the lower income earning spouse that would cover all of the alimony that is the obligation of the alimony, use some discounted cash flow and move it from the 401k into an IRA for the ex-spouse. Then if they're over 59 and a half, the ex-spouse could take the money out of the 401k. There's no 10% penalty, and they'd be taking it out at a lower tax bracket, therefore playing a little tax arbitrage. Like I said before, if they're under 59 and a half, there are ways to take money out of an IRA without having to pay the 10% penalty. And so that's one of the ways that we've looked to create steady cash flow and be able to mitigate some of the taxes based upon the new tax change when it comes to alimony.
Yeah, that's great. Those are some really creative ways and some really great solid advice. Thank you.
My pleasure.
And just one note before we move on. Often we get questions about child support and whether it's deductible by either the paying or receiving parent. Child support payments are not deductible by the parent making the payments, nor are they taxable to the parent receiving them. That actually has not changed. So essentially child support and alimony, or you call it spousal support, now they're basically treated the same on their taxes.
Right.
So our next mistake mainly applies to women, and it's this. If you are changing your name as part of your divorce, make sure you get your Social Security card changed to reflect your new name, as well as any W-2s or other documents needed to complete your taxes. If your old name still appears and conflicts with your new name you have filed your taxes under, it can lead to problems like tax filings being rejected or refunds being delayed, which obviously nobody wants. So get the name changed. Make sure you take care of that. Your divorce decree can serve as proof when you go to change your name to these official documents. So that's just one tip oftentimes people forget. So our next mistake is a little bit more involved. Now let's say that you separated in 2019 and you open up the mailbox one day and discover a notice from the IRS addressed to you and your spouse that you owe back taxes, or that a mistake was made on a recent or prior tax return. You were never the spouse who took care of these taxes. You just didn't know, and you trusted that your husband or wife was taking care of it correctly. So all you did was sign off, and you basically trusted that that process was taking place. So the question is, are you on the hook for any money owed to the IRS for mistaken or fraudulent returns that you had knowledge of? The short answer might be no, and you may qualify for certain protections called the innocent spouse relief. I'm going to turn to Michael to explain exactly how that might work.
You know, you're absolutely right. This is one of those things that happen all the time where one spouse is not really educated on what the other spouse is doing when it comes to their personal finances. And you're right. You know, somebody can open up the mailbox one day and see that they owe a significant amount of money in taxes based upon, you know, trusting the other spouse. And if that does happen, and it happens often, the IRS does have an innocent spouse rule for relief of any taxes, any interest, any penalties that would be due if for some reason you can prove that you know, you really had no knowledge of what the other person was filing. And it could be anything from them not reporting income that they earned to over-exaggerating tax deductions. And, you know, a lot of times when you open the mail and you see that letter, it's an initial shock. But as you mentioned, there are ways that, you know, you could become not liable for the, you know, tax mistakes or improprieties that your ex-spouse has made.
Right. And now we also have something, a protection called separation of liability relief. So how does that differ from the innocent spouse relief? Who can claim that?
Well, that's a little bit different. That's if, you know, when you're separated, you can allocate the additional taxes that are owed, but that you're responsible for. So you can actually take the tax return, go through it, find out what your taxes are, what you would be responsible for, and then as opposed to the innocent spouse relief where you may not owe anything, in this case, you might be just liable for the taxes that you owe on the amount of money that you earned during that time period.
Okay, understood. Great. So after all that, we want to end up with some good news, right? So we've talked about some things to really avoid, but there's some good aspects and some good tax implications with regard to the divorce. So after your divorce, there's additional tax cuts that you might be entitled to. So certainly don't make the mistake of passing those up. The first of these tax cuts comes from medical expenses you may pay for your child. Even if you don't get the child tax credit, if you're paying out of pocket for things like dental and vision, therapy, certain medical equipment, travel to and from appointments, if you pay for certain surgery, and these costs add up to more than 10% of your API, you can deduct these expenses. And finally, there is a laundry list of things that you can do to minimize your tax burden. If you are new to filing taxes, take the time to dig in and learn about everything that you can do. So Michael, can you explain some of the things that people can do?
Sure. I think first and foremost, when you're starting fresh, is to really be able to get a good handle of your financial situation. Most people's financial world in their life it's like a junk drawer in the kitchen. You know, throughout their life, they just acquire financial products and stuff. There's no strategy, there's no coordination, and because of that, there's no confidence that you're going to be making good financial decisions moving forward. So, number one, you're right. Keep your finances organized. Start from the beginning. You have a fresh start. Take a look at everything that's going on and start creating a spending plan, protect your finances, and also really take a look at how much money you may owe in taxes that year and do some proper tax planning. Because the last thing you want to have happen is, you know, most people, when they get a tax refund, are really excited about it. And what they don't realize is that you've basically given the government a tax-free loan for the last year. So do some tax planning, check your W-2s, change some of your exemptions to be able to take about the right amount of taxes. Take a look at contributing to your 401k. If you don't have one at work, you can actually set up an IRA to start saving money for the future. You mentioned a health savings account. That's a way to put money into an account for medical expenses using pre-tax dollars. So I would talk to a financial or an accounting professional. Take a look at what's going on in your financial life, and more importantly, use it as a way to build confidence around your money and to really have true purpose for your money.
Great. So that wraps up our discussion for today. I hope that as 2019 begins to draw to a close and tax filing time arrives once again in the new year, that today's presentation gives you some food for thought as you navigate your taxes. I want to give a special thanks to our guest, Michael Ringel of Strategies for Wealth and Wall. It was fantastic to have your insight, really helpful information in today's presentation. Very special and helpful, and thank you for that, Michael.
Well, thanks for having me. I appreciate it. Anything else I can do, feel free to let me know.
Yeah, and why don't you just tell everyone where you can be reached and how you can be reached?
Sure. My phone number is 917-734-4748. My email is mringel@strategiesforwealth.com. And I don't charge for an initial consultation to just sit and talk and learn about, what somebody's financial situation is about, share some ideas with them, and hopefully, help them really get empowered to discovering what their troopers for their money is and purpose for their life.
Absolutely. Thank you again. And if anyone has any questions about your divorce or specific questions about divorce or tax situation, we're absolutely here to help. You can call the law firm at 888-888-0919 or email at info@weinbergerlawgroup.com. We also offer free consultations, and we're here to absolutely help safeguard your future. So thank you for joining us. Take care and be well.